Hi, everyone. Good afternoon. My name is Cliff Kirsch, and I'd like to welcome you to the Eversheds Sutherland Webcast, Planning for Best Patchwork of Best Interest Standards. And, we're planning on doing a number of these throughout the year as developments warrant, and we expect it to be a very active year in this regard. So thanks for joining us. I'm joined today by my Eversheds Sutherland colleagues, Michael Koffler, Holly Smith, Issa Hanna, and Bria Adams. And before we begin, a few housekeeping notes. First, if you'd like to receive CLE credit for this webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. Also, if you have any questions during the webcast, please submit them via the Ask a Question text box on your viewing console. And last, contact any one of us. Please feel free to do so if you want to receive a hard copy of the slide deck. We're very, very happy to make that available to you. So with that, we have a lot to cover, and thanks again for joining us. What we're looking to do on this series and future series is really help you start thinking about the patchwork of best interest standards, because there's a lot going on from a number of different directions. So, obviously the SEC continues to advance its regulation best interest. We're going to talk a little bit about that today, but also spend a good amount of the hour talking about state securities developments in Nevada and Maryland, very concrete, tangible developments there. And New Jersey, which we're not going to spend time on today, but they're not too far behind, and on our next webcast, very likely talking about New Jersey. Then we want to pivot to the state insurance side, and we'll be talking about New York Insurance Regulation 187, and although it's an insurance regulation, it has a very, very significant impact on broker-dealers and advisors who are involved in the sale of annuities. We're also going to talk about anticipated DOL rulemaking, and we're not going to mention much today about the DOL rulemaking, but we just ask you to keep it in mind because, again, it's anticipated that this fall the DOL will take action in concert with the SEC regulation best interest, but we don't know how coordinated, the timing, or anything like that. The DOL has not been actively discussing that. But again, it's something that we need to keep in mind as we sort of talk about this patchwork. So to begin, I'm going to turn it over to my colleague, Michael Koffler, who's going to talk about regulation best interest and some of the developments there.
Sure. Thanks, Cliff. We still see the SEC working toward a fall adoption of regulation best interest, along with the associated rulemakings like Form CRS and the Investment Advisors Act interpretation of the fiduciary duty for investment advisors that are registered with the SEC. We have noted there are some headwinds, which we're going to be talking about some of which today. The states being really the most active in the area. And in the last few months, you've seen two types of activities. First, you've seen a second comment letter from NASA, which of course is the umbrella group for the state securities regulators. And it submitted a second comment letter on February 19th, which was very, very critical, as was the initial comment letter, about the proposed regulation best interest, basically saying the SEC, you're catering to the brokerage industry, you're giving free rein for them to provide conflicted advice as long as the conflicts are disclosed. You need to really specifically address, not just in the release, but also the rule itself, things like broker-dealer sales contests, revenue sharing payments, rollover recommendations, etc. Basically, the thrust of the comment letter was this is not going to change anything in practice. It's just going to require some additional disclosure, but all the conflicted advice that broker-dealers provide will continue. That's kind of the thrust of their letter. You also, those sorts of concerns by the states of looking at regulation best interest as more of a cosmetic fix more than changing substantive practice is why we think you see states like Maryland and Nevada, proceeding with their own regulatory frameworks in this area. So some of the concerns that are expressed in the comment letter really the same sort of concerns that are leading the states to come up with their own proposals. The second thing, kind of headwind we see is an announcement by Rep. Waters, Maxine Waters, who's the chairwoman of the House Financial Services Committee. She announced that on March 14th she's going to hold a hearing on regulation best interest. She's kind of already made clear that it's going to be kind of a grilling of Chairman Clayton as to what regulation best interest will and will not do. You might recall that she was one of the 35 House Democrats who wrote a letter last year criticizing regulation best interest, saying it's not a fiduciary standard, you're not getting to where you need to be. So it is expected to be pretty much a grilling on March 14th. We don't see that really slowing up the rulemaking process of regulation best interest. I think the real question will be whether that grilling combined with the comment letters from NASA combined with the proposals from the states will have an impact on what is adopted in the final rule package in terms of will some of the stuff that was in the let's say the release in the proposal, will that make its way into the rule itself, and will the commission come back and say, well, maybe there are certain conflicts that really can't be disclosed that really need to be addressed. That's a thing to watch out for in the adoption, but we don't see this having a material effect on the timing of the rule package. We think the commission staff is still going 100% full speed ahead.
I guess the title of the hearing, I think it's like regulation best interest, putting in best interest first with a question mark.
With a question mark, right?
Yeah, so I think that sort of signals sort of the line of analysis or questions that the SEC would get. And I agree, there's not an avenue for them to directly get involved in the rulemaking. They could formalize a resolution denouncing any rule or something like that, but in terms of the actual rulemaking, it's hard for them to influence the timing. As for the state, you mentioned NASA's letter dated February 19th, and you mentioned there's a couple of NASA letters. This one, just along the lines of what you're suggesting, has a lot more force and energy.
Right.
And whereas the first letters sort of operated within regulation best interest as proposed, this one again, it has a lot of energy.
Right. Instead of focusing on, can you tweak this or fix this, it's, hey, the SEC, you're missing the boat.
Right.
You need to redirect, refocus, and come at this from a different perspective. So yes.
Hey, along the lines of talking about the states and the state activity, Holly, if it's okay with you, we're going to have you pass it on to you to talk about and tee up the Nevada discussion.
Yes, thank you, Cliff, and good afternoon, everyone, and thank you for joining us. We wanted to focus on Nevada state law today because Nevada does seem to be moving ahead with the adoption of fiduciary duty regulations that will impact all broker-dealers and investment advisors and their salespersons who are doing business in the state of Nevada. This is obviously a very important development. We will be confronting the possibility that the standard of care that is applicable to the broker-dealer and investment advisor businesses may end up not being harmonized between the federal and state level and among the various states. So that ties back into the title of this webcast, which is the patchwork, right? Because this is increasingly looking more like a reality. So when we look at Nevada, what's going on there? In order to understand it, you have to recognize that Nevada for some time has had within its statutes a definition of financial planner. A financial planner is a person who, for compensation, advises others upon the investment of money or provision for income. And so there's nothing really notable there except within the Nevada statute until July 2017, broker-dealers and investment advisors were accepted from the financial planner statute. And that exception meant that they were not subject to the fiduciary duty that is owed to a client in the state of Nevada by a financial planner. In July 2017, the Nevada legislature amended the definition of financial planner in the state, and that amendment took away the exclusion of investment advisors and broker-dealers from the definition of financial planner. So starting in the summer of 2017, actually, broker-dealers and investment advisors in the state of Nevada owed a fiduciary duty to their clients. So that's, almost 2 years ago. But what has happened most recently in January of this year is that the Nevada Office of the Secretary of State in the Securities Division published a notice of draft regulations and request for comment to adopt fiduciary duty regulations that will implement what it means for a broker-dealer or an investment advisor to have a fiduciary duty in the state. So that's how we get to this position of, what did Nevada do to its own laws to get us to the point where we are looking at a differentiation between Nevada and perhaps where the SEC and the DOL and other states choose to go. So if you go on to the next slide, what I'm going to try to walk you through are the draft regulations that Nevada has out there right now for comment. I will note for everyone, there's a very short comment period here. The proposed regulations were published on January 18th, and comments are due to the state of Nevada by this coming Friday, March 1st. So if, perhaps you're already part of a group that's working on a comment letter, or maybe you'll want to put in your own comment letter, but comments are due by this Friday. So when you look at the proposed regulations, the first thing that I think is interesting is that there are 10 sections. And what you see on this slide are the titles for the 10 sections. And I did that on purpose because you really have to go section by section by section and then stop and think about it and then probably go back and read it again, frankly, because it builds on itself. So, for instance, the first section is about the fiduciary duty that will be owed by broker-dealers and their sales representatives. So it's just talking about broker-dealers. But then you go into Section 2, and it's creating an exemption when broker-dealers can comply with an exemption. It's called the episodic fiduciary duty exemption. It has many qualifications, and I'll get to that later. Then you come to Section 3, and we have a section that deals with the fiduciary duty being applied to investment advisors and their representatives. Then you come to Section 4, and it's very important because it defines the term investment advice. And for reasons that I'll explain, the definition of investment advice becomes pretty much the linchpin upon which these regulations are built. Section 5 is exemptions from the fiduciary standard. There are not a lot of exemptions there, but there are some. Section 6 is conduct that is not a per se violation of the fiduciary duty. This is where you see reference to the sale of proprietary products, and that becomes, of course, of interest to all broker-dealers that, not every broker-dealer has proprietary products, but many do. Section 7 is disclosures that must be given to the client at the time the advice is given. Section 8 defines what it means to breach the fiduciary duty, or in other words, what activities could you engage in that would be viewed presumptively as a breach of the fiduciary duty. Section 9 has certain presumptions and burdens in it, and then Section 10 relates back to NISMIA and is a statement by the state of Nevada that it intends the regulations to be interpreted and applied in harmony with NISMIA, particularly with respect to the part of NISMIA that deals with the authority, the limitations on a state's ability to adopt regulations that conflict with SEC regulations. So that's how the draft regulations are set up. The next slide, I am just trying to give you a general overview. As you probably gathered from what I've already said, these proposed regulations, if adopted in their current form, will impose an ongoing fiduciary duty on broker-dealers, their sales reps, investment advisors, and their sales reps. It will prohibit any of those categories of persons and businesses from recommending a security or a strategy that is not in the client's best interest. It is something that everyone should probably realize when they're reading this proposed regulations, that they do not define the term best interest. Rather, the term best interest is used in certain of the sections that I just went through as a way to say that if you do something that is not in the client's best interest, you will be deemed to have breached your fiduciary duty. Now, it doesn't define best interest, but as I was saying a minute ago, it does define the term investment advice. I'll go into that more in a minute, but that definition of investment advice becomes very important. And among other things, the proposed regulations prohibit recommending or charging a fee that is unreasonable, and there is no definition in the proposed regulations of what is reasonable or what is unreasonable. So as a reader, that is something that you would have to, contemplate, based on what your current fee structure is. I'm going to focus now for a minute on the next slide on Section 4. Section 4 is the name of Section 4 is called terms. But the term that is defined in Section 4 is the term investment advice. This becomes crucial because a breach of the fiduciary duty is keyed off of whether a broker-dealer or an investment advisor or one of their salespersons is providing investment advice to a client. So what Nevada did here was list 12 different presumptive acts, which if you do this, one of the presumptions, you will be deemed to be providing investment advice, and therefore the fiduciary duty that you owe to the client will be triggered. So when you look at the list of 12, certain things I think would not be particularly surprising to people. For instance, the first one on the list of 12 is providing advice or a recommendation regarding the buy, hold, or sale of a security to a client. Other things might be more surprising to people or might not be totally in line with your current business models. For instance, if you provide advice or a recommendation regarding the type of account a client should open, that will be under this trigger of investment advice. If you provide advice or a recommendation regarding fee options, that constitutes investment advice. If you provide a limited list of securities, but the limited list has been tailored with consideration to the particular client or group of clients to whom you're speaking, that will be considered investment advice. If you recommend a financial professional, maybe you are not the right person to provide advice to this person, but you think someone else is, the mere act of recommending a financial professional comes within the rubric of investment advice. that's in Section 4. So turning to the next slide, I wanted to talk a little bit about exemptions to the fiduciary standard, because the way the proposed regulations are written, since broker-dealers and the investment advisors are presumed to have a fiduciary duty, then you have to start to ask yourself, are there any circumstances in which a broker-dealer, for example, can execute a trade? Or what does a clearing firm do? Because a clearing firm is a broker-dealer by definition, so does it have a fiduciary duty obligation? And what the state did with respect to some of these issues is create certain exemptive provisions within the proposed regulations. The first place you see it is in Section 2, where something called an episodic fiduciary duty exemption was created. So basically what an episodic fiduciary duty exemption is it's a way for broker-dealers and their sales reps to assist a client to a certain degree and not have a fiduciary duty related to the advice that they're giving to the client. Now, I will say there are many ins and outs of the episodic fiduciary duty exemption, by which I mean you are not allowed to claim the exemption unless like I'll say half a dozen or more things are applicable to you. So in other words, it's a very qualified exemption, and you would have to jump through, a lot of hoops in order to say that you were relying on the episodic fiduciary duty exemption. The other thing I'll say about it is that you may think that you are correctly relying on it, but it appears from the regulations that it can, after the fact, be quote unquote revoked. So in other words, you do a particular transaction and you think that you didn't have a fiduciary duty, but then, if the client says, well, I thought you did have it. Anyway, I'm pointing this out because it is not something that you can claim and then sort of claim and be safely within that kind of a safe harbor. It actually is something that can be revoked later if it was not properly, you thought you were applying it properly, but you turned out not to be. So, and one other thing to note here, there is provision in the proposed regulations that prohibit the broker-dealer or investment advisor from using any one of a number of titles that could be deemed to give the impression that you are acting as a fiduciary. So in other words, you can't say, I'm an advisor or a financial planner or a financial consultant or a wealth manager or a retirement consultant. Those kinds of things would immediately put you in the category of having a fiduciary duty, and you could not claim any exemption from the fiduciary duty because I think the state's position is you presumptively have conveyed to your clients that you, in fact, are a fiduciary. So then I'll move on to the next slide, which is Section 3. I wanted to mention this issue about dual registrants in Section 3 and call it out to everyone because it is, noteworthy for all broker-dealers and investment advisors that are doing business through the same legal entity or through related legal entities, meaning through common ownership, perhaps, of a broker-dealer and an investment advisor. What the state has said in the proposed regulations is that an investment advisor who also acts as a broker-dealer, whether through the same entity or related entity, and all of their salespeople will be presumed to be acting in their capacity as an investment advisor. And once that presumption attaches, then you cannot rely on the episodic duty exemption. So in other words, it appears that the state is saying all dual registrants in our state, whether they're acting through a single legal entity or they're acting through multiple legal entities, will be presumed to be acting as investment advisors. So we wanted to point that out to everyone. The last thing I'll mention is Section 9, and this is on the next slide. Section 9 is also very important. I'm going to read this to everyone just so, because of its importance. A broker-dealer and sales representative shall each be presumed to owe a fiduciary duty to the client. The broker-dealer and sales representative have the burden of proving in an arbitration, civil, or administrative hearing that an exemption to the fiduciary duty exists. So in other words, I think in Section 9 you see everything come full circle, at least with respect to broker-dealers and their sales representatives. They will be presumed to owe a fiduciary duty. It will be triggered by all of these sections and the definition of investment advice and the regulations that are being adopted, being proposed to be adopted by the state of Nevada. And then once triggered, unless you felt that you could really claim an exemption through these regulations, you really won't be able to rely on an exemption, and you have the burden of proving that an exemption existed. The other thing, or the last thing I'll point out here that I think is something people should note, is that under Nevada law, there's a particular reference to liability of financial planners. And this is important because if a client believes that they have incurred a loss because of the financial planner's advice, then the client may recover from the financial planner in a civil action the amount of the economic loss, all costs of litigation, and attorney's fees. So there is a right of action on the part of the client to say that he or she believes that the fiduciary duty was not properly applied with respect to the advice they were given. I'm going to stop right there because I want Bria and other people to be able to talk about what's going on in other states. But as you can see, Nevada definitely, these proposed regulations are something that I think should be on everyone's radar screen at this point. Bria, do you want to tell us what's going on in Maryland?
Thanks, Holly, and good afternoon, and thanks for joining us. On February 4th, the Maryland General Assembly introduced the Financial Consumer Protection Act of 2019. It spans 50 pages and proposes amendments to a variety of laws related to financial transactions. Most importantly, it amends the Maryland Securities Act to include a fiduciary standard. The proposed amendments apply to broker-dealers, broker-dealer agents, insurance producers, investment advisors, investment advisor representatives, and federal covered advisors. And the standard is that when providing advice, these persons would be required to act in the best interest of the customer without regard to the financial or other interests of the person or firm providing the advice. The amendments also permit the Maryland Securities Commissioner to adopt regulations, including those that define, require, prohibit, or exclude an act, practice, or course of business, or prevent persons from engaging in acts, practices, and courses of business in violation of the fiduciary standard. On the next slide, to give you a little background on the Financial Consumer Protection Act of 2019, it was proposed immediately after the issuance of the Maryland Financial Consumer Protection Commission's 2018 final report. And some background that's not on this slide, but relevant here, is that the Maryland Financial Consumer Protection Commission was formed by Maryland's lawmakers. Specifically, it was formed to assess the impact of potential changes to federal financial industry laws and regulations, budgets, and policies, and to issue recommendations for federal and state actions that are intended to protect residents of Maryland when conducting financial transactions and receiving financial services. This past year, Maryland's lawmakers specifically mandated the Commission to study the U.S. Department of Labor's fiduciary rule and any SEC actions in addressing conflicts of interest of broker-dealers offering investment advice by aligning the standard of care for broker-dealers with that of the fiduciary duty of investment advisors. And they also mandated the Commission to include recommendations in their final report regarding changes to Maryland's laws to provide the protection intended by the DOL rule. As we know, it's been vacated, but addressing fiduciary standards of care. So the Commission's members include, among others, a former chairman of the CFTC, the Attorney General of Maryland, Maryland senators and delegates, and other financial industry stakeholders. Now back to the slides. The Commission's 2018 report includes the following key recommendations. First, the individual states may need to provide greater protections that investors expect from financial professionals who provide investment advice. Second, the report recommended that the Maryland General Assembly pass legislation which provides that a broker-dealer, broker-dealer agent, insurance producer, investment advisor, or investment advisor representative who offers advisory services or holds themselves out as advisors, consultants, or as providing advice would be held to a fiduciary duty to act in the best interest of the customer without regard to the financial or other interests of the person or firm providing the advice. Next, the report recommended that Maryland's legislators strengthen Maryland's fiduciary standard with respect to investment advisors. And finally, the report recommended that Maryland's legislators should provide an exception for broker-dealers and insurance agents to operate under a suitability standard so long as they do not engage in providing advice or hold themselves out as providing advice. On the next slide, a few key takeaways from this proposed legislation includes the following points. First, the proposed fiduciary standard is significantly different from the fiduciary standard that was proposed but not passed by the Maryland General Assembly in 2018. In 2018, the proposed fiduciary standard only required a person to act primarily for the benefit of its clients. That's very different from what we see here. A second difference is that the fiduciary standard proposed in 2018 required a person to make disclosures related to compensation and disciplinary events, and also it required them to make inquiries into a client's financial circumstances and obligations. And we don't see any of those requirements included in the amendments that have been proposed. Second takeaway is that the current proposal does not expressly limit the fiduciary duty to advice that is provided with respect to securities or variable products. It's unclear what products are covered by this particular legislation, or what is intended to be covered by this particular legislation. And finally, the current proposal states that it does not impose any books and records requirements on broker-dealers that are not already imposed under federal law. So this is similar to what Holly mentioned with Nevada. It appears that this is an attempt by Maryland's lawmakers to deal with the issue of preemption under NISMIA. And in closing, the Senate and House have scheduled hearings on the Financial Consumer Protection Act as a whole for March 12th and 13th of 2019 at 1 p.m. So I think we'll be looking forward to further developments. Now I'll hand it over to Cliff to provide any final thoughts.
Yeah, well, thanks, Bria, and thanks, Holly. That was a great discussion. So just, I should know we received a lot of questions, and what we'll do our best to get to it at the end. For those of you who'd like to receive CLE credit, I'll repeat the code, but I just want to say for today's webcast, our confirmation code is STANDARDS, STANDARDS, standards. So please use this code for the sign-in sheet available for download from your viewing console. And again, for those of you who are looking to receive CLE credit, our confirmation code is STANDARDS. So what we just covered was on the state security side developments. One, in terms of Maryland, a legislative development, and second, in Nevada, proposed regulations. Now we're going to pivot to the state insurance side, and we're going to be talking about an effective regulation, something that in place and is going to have a very, very significant impact with respect to insurance sales, including broker-dealers and advisors who are involved. So we're going to turn it over to Issa Hanna to walk us through that material.
Thanks, Cliff, and thanks to everybody on the line today for joining us. We really appreciate it. We know that there's some interesting things going on in D.C. and Congress today that could otherwise be taking your attention, but we appreciate that you joined us on this webcast today. So today I'm going to discuss New York Insurance Regulation 187. I provided a little bit of an overview of where we're going to go with this discussion here. The first thing that we're going to talk about is just provide a high-level overview or some background on the First Amendment to Reg 187, go over some of the key changes and the high-level consequences of the amendment. Second, we're going to discuss the hook, how broker-dealers and investment advisors get roped into this new New York Insurance Regulation 187, how it is that an insurance regulation is impactful for broker-dealers and investment advisors. Third, we're going to provide a little bit of context about how the insurance regulation came to be and what we can, kind of understand about that rulemaking history, that context, and how it plays into the regulation. Next, we're going to kind of provide just a brief overview of some legal challenges that have arisen with respect to the amended regulation. Next, we're going to get into the gory details of the regulation and kind of provide an understanding of some key terms that are important to understand what the regulation really means. Next, we're going to get into what the best interest standard is, how it is that a firm can get into compliance with the best interest standard. Then we're going to just go over a few miscellaneous new requirements, and we're going to close with some implementation issues, some kind of practical consequences of the regulation. So jumping right in here, just at a high level, this slide is kind of designed to provide a little bit of background on what the key changes were and what the impacts are on all the impacted parties. So just a few of the key changes that are resulting from this amendment to Insurance Regulation 187. Clearly, it imposes a best interest standard on recommendations with respect to life insurance and annuity transactions. That best interest standard is an entirely new development under Reg 187. Previously, it was just a suitability standard. Now we have a best interest standard that's layered on top of the existing suitability standard. Next key change is that the regulation now applies to life insurance. Previously, it only applied to annuities. Now it applies to life insurance, even term life insurance. The next key change is that it extends to certain in-force transactions. This is a completely new concept. Previously, the regulation really only applied to transactions relating to an initial, purchase or replacement or exchange transaction. Now, it will apply with respect to in-force policies. If you make a recommendation with respect to an in-force policy, there is a fallout here under New York Insurance Regulation 187. There is an obligation here. At a high level, what's the impact on insurance producers? As I said, there's a new standard of care that you have to comply with, and it's layered on top of the existing suitability standard when you're making a recommendation with respect to a life insurance policy or an annuity contract. Another kind of key impact is that that best interest standard applies to recommendations to hold for FINRA member broker dealers who are already in compliance with FINRA Rule 2111. That standard or the applicability of that standard to hold recommendations is not necessarily anything new. There's already existing processes there to kind of deal with that. But if you're an independent agent and you don't have an obligation to comply with FINRA rules because you're not a registered broker-dealer, that is something that you'll have to find a way to get into compliance with. That's something that it does not exist under, in your current compliance world. Finally, there are new training requirements. Insurance producers are going to have to deal with training that's keyed to the best interest standard in particular. Insurance producers should already be familiar with training on particular products. That's provided usually by the insurance carriers that they work with. Now, because of this amendment to insurance regulation, there's a second layer of training that's going to have to be that's going to come into place, and that's going to be designed to kind of train the producers on how they comply with the best interest standard. That's a specific obligation under the reg. The insurance companies have to ensure that insurance producers are provided with that training. With respect to the insurance company community, what is the impact on them at a high level? Well, they have enhanced supervision requirements. They already had a supervisory obligation under Reg 187. That supervisory obligation has been enhanced under amended Reg 187. And they already were able to subcontract their supervisory obligations to third parties under Reg 187. That ability continues to exist under amended Reg 187, and there's kind of a related fallout here for producers. There's going to be more potentially put on their plate to help the insurance companies meet their supervisory obligations. We'll get into that a little bit more later. With respect to effective dates, there's a staggered effective date process here. For annuities, the effective date is August 1st, 2019, which is right around the corner. For life insurance, the effective date is February 1st, 2020, which is 6 months later. So there are a number of companies now that are really ramping up their efforts to get into compliance with this. In terms of how this ropes in broker-dealers and investment advisors, really the hook is if you have a New York insurance producer license, or if you have an affiliate who has a New York insurance producer license and you're kind of operating in a networking arrangement. If you have one of those licenses for the purpose of recommending a life or annuity product, that's the hook. That's how you get roped into having to comply with this amended New York Insurance Reg 187. It's important to note, and this is going to be important for the broker-dealer community, that amended Reg 187 does not really allow you to rely on the FINRA suitability standards anymore to kind of establish that you're complying with the standard of care obligations under that reg. The current or the existing version of New York insurance regulation doesn't necessarily have that carve-out for FINRA, for compliance with the FINRA suitability standards that the NEIC model does. But there was always a common understanding in the insurance producer community and the broker-dealer community that if you complied with the FINRA suitability standards, that got you most of the way there with respect to New York. That is no longer the case under the the amended insurance regulation 187. There are additional responsibilities here. Next slide here provides a little bit of context, just to look at this kind of in a recent historical perspective to see the context in which this New York insurance regulation, or the amended New York insurance regulation 187 came to be. So the first point to note here is that it really, the activity at the New York Department of Financial Services with respect to this amendment really got ramped up at around the time when it became obvious that the DOL rule's days were numbered. As I note here, the DOL rule was struck down in March of 2018. It just happens to be that DFS was making significant efforts on amending Insurance Regulation 187 around that time, and I don't necessarily think that's any coincidence. And the reason why I say that is because there is a DFS press release that came out at the same time that the insurance regulation was adopted toward the end of last year, toward the summer of last year, and in that press release, DFS said that the rule was designed to fill in regulatory gaps that they believe were created when the DOL rule was struck down by the Fifth Circuit. So it's important to understand that context and that framing by DFS. They really see this regulation as a state effort to fill that gap that was left by the DOL rule being struck down. It's also important to recognize that DFS is really trying to get ahead of a couple of important regulators here. You'll see, we provide a timeline here with respect to the NEIC efforts to put together an amended annuity suitability reg. And one thing that DFS did is that they got their amendment to 187 done before the NAIC really ramped up their efforts. So you can kind of surmise by this that that DFS is really trying to set the table here to kind of direct the conversation here at the NAIC and hope that their regulation has a nationwide impact. Third thing to note is that the New York Department of Financial Services did not wait for the SEC to implement to implement their regulation best interest. They went ahead with their amendment to Reg 187 without waiting to see how it would play out under Reg BI. So you could tell here that they have their own agenda, and they feel that they're entitled to kind of do what they feel is right for New York consumers. I just wanted to briefly mention some legal challenges that have come up with respect to amended Reg 187. There are a couple of groups that are representing the insurance producer community in New York that have filed a couple of lawsuits against the New York Department of Financial Services to try to get an injunction against the effectiveness of the regulation. There really hasn't been much yet in terms of the development there. Haven't really heard anything yet in terms of whether that lawsuit might be successful in terms of getting an injunction, delaying the effective date, or anything like that. It's still kind of on hold, and we're continuing to monitor it. But one kind of fallout from the lawsuit is that DFS has kind of gone silent. They're not really providing any kind of guidance or formal published guidance about how to interpret the regulation, which is unfortunate because there are a number of companies right now that are trying to get into compliance with the reg and running into those running into interpretive issues, and they can't really go to DFS to get help on how to resolve those. So that's an unfortunate fallout from the litigation, but definitely something to keep an eye on. Now getting into the guts of the regulation, thought it would be helpful to go over some key terms to kind of understand really the key impacts of the regulation. First thing, obviously, to take a look at is the definition of recommendation, and one thing that really stands out is this definition of recommendation similarity to the DOL rule. The phrasing and the terminology is very similar to the way that the Department of Labor formulated the definition of recommendation under the former DOL rule. So it might be helpful to take a look at previous guidance that the DOL offered about what is and what is not a recommendation and kind of interpreting what this might mean, given that DFS is really not providing any guidance in that regard right now. The second thing to kind of note is that there's a specific reference in here about advice to refrain from entering into a transaction in accordance with advice. So clearly here there is an applicability to recommendations to hold. They provide a few exceptions to the definition of recommendation, which should not be entirely surprising to folks. I think these are pretty common across the board in the regulations that have been trying to impose a best interest standard across all states. Some key terms relating to suitability information. It's important to note here that there's two definitions of suitability information. One definition that applies to term life insurance, and another definition that applies to all other policies. And one thing I did here is that I bold and italicized those two components of the suitability information definition that are different from the definition that applies to term life insurance. So when you're collecting suitability information in connection with a recommendation relating to a non-term life policy, you have to collect information about financial experience and tax status, whereas you do not have to collect that information with respect to term life. It's also important to note that there are certain suitability components here that have been expanded. So in the amendment to Reg 187, they now require you to collect information about the intended use of any riders. Previously, they only required you to collect information about the intended use of the policy generally. Now they also ask you to collect information about the intended use of any riders. Second, previously they only required you to generally collect information about financial time horizon. Now the amended Reg 187 is requiring producers to collect information about the duration of existing liabilities and obligations. That's also an expansion. Finally, this is a completely new element. This new definition of suitability information will now require firms to collect information about the consumer's willingness to accept non-guaranteed elements in the policy, including variability in premium, death benefit, or fees. That's something that never existed and that a lot of firms are grappling with at the moment about how they're going to document that. Next, getting into the definition of sales transaction. This is an important one, and it's caused some confusion in the industry. So it's important to kind of understand that a sales transaction is not just a recommendation to buy a new policy. It's a recommendation that results in new sales compensation generally, and that can come up in the context of somebody purchasing a new policy or somebody modifying or electing a contractual provision with respect to an in-force policy. So there are some in-force policy recommendations that can rise to the level of a sales transaction. It's important to note that nuance, that a sales transaction can come up in the context of both a new sale and a recommendation with respect to an in-force policy. One thing I provided here on this slide is a quote from the DFS Assessment of Public Comments that tried to provide some clarity around when an add-in or a dump-in to an in-force policy would or would not amount to a sales transaction. I quoted the exact language here. Unfortunately, even though DFS thought that this language or this clarification would provide clarity, a number of folks in the industry are actually a little bit concerned about the language and think that it's actually confused things. So it's not clear right now the extent to which renewal compensation or add-ins might give rise to a sales transaction or not. So that's something to watch for, hopefully additional guidance. An in-force transaction. This is another term under the rule. It's important to understand the difference between a sales transaction and an in-force transaction. And basically, the key difference is that an in-force transaction does not generate new sales compensation. The important thing to note with respect to an in-force transaction also is that it's subject to a best interest light standard. It's not subject to the full requirements of the best interest standard that would apply to a sales transaction. Instead, it's subject to a best interest light standard. I'll provide a little bit more clarity on what that really means in just a moment. So what is the best interest standard, or how do you meet the best interest standard with respect to sales transactions? These are the components of this with respect to what it means to come into compliance with the best interest standard. You have to make a recommendation. Your recommendation has to be based on these first three initial factors, and you have to have a reasonable basis to believe certain information. And then moving to the next slide here, you also have to, at the time of the recommendation, have to make certain disclosures to the consumer and document certain things. So there's a lot here. There's a lot to break down. But the two key components, I think, of this best interest standard that are important to kind of get your arms around is that, first, the recommendation has to reflect the care, skill, prudence, and diligence that a prudent person in like capacity and familiar with such matters would use under the circumstances then prevailing. That is a new formulation of a standard of care under this amended Reg 187 that is important to kind of get your arms around and document. The next thing that a lot of firms are grappling with is this obligation to disclose to the consumer in a reasonable summary format all relevant suitability considerations and product information. There's this new disclosure obligation that you have to follow through on, and that is what the industry right now is really working toward to kind of figure out their game plan in terms of how they're going to comply with that. But those are the two kind of critical components of this new standard. Moving on to the best interest standard and how it applies in the context of in-force transactions, or what I like to call best interest light, you'll see here that the obligations are significantly slimmed down. And the key things to understand about the best interest light standard is that you do not have to conduct a suitability review, and that you do not have to provide a reasonable summary format disclosure with respect to in-force transactions. There's really only an obligation to kind of comply with that general standard, that your recommendation reflects the care, skill, prudence, and diligence that a prudent person in like capacity and familiar with such matters would use under the circumstances then prevailing, and then you have to have a reasonable basis to believe that the consumer has been appropriately informed of the policy features and potential consequences of the transaction. Some miscellaneous new requirements that are important to keep track of in this amended Regulation 187. And this is the first miscellaneous requirement here is a sales transaction restriction that applies to policies subject to lapse. So the amended Reg 187 prohibits you from recommending a sales transaction unless you have a reasonable basis to believe that the consumer has the financial ability to meet the financial commitments under the policy. And basically what that's getting at is if you have information that would indicate that the consumer is not able to meet the ongoing premium contribution requirements to the policy, then you can't recommend that policy to that consumer. Second is another miscellaneous requirement that relates to titles and descriptions of services. This will look very familiar to those who have been keeping track of Reg BI. Basically, what DFS is saying here is that you're not permitted, or it's basically a fraudulent device to make use of a title or a designation or provide or describe your services in a way that is not true. So those are a couple of important miscellaneous requirements to kind of note in this new amended Reg 187 that just didn't exist under the old version. So what are the implications as producers seek to come into compliance with this reg? Well, you need to obviously go further than the FINRA suitability rule now. Compliance with the FINRA suitability rule is no longer enough. There's a standard of care now that looks and feels a lot like the Department of Labor fiduciary rule standard. It seems like, based on this obligation that only the consumer's interest is considered and the amount of compensation and receipt of an incentive does not influence the recommendation, it sure does seem like there might be an expectation that insurance producers will have to find a way to eliminate conflicts of interest relating to compensation, potentially have to levelize compensation so that insurance producers don't have an incentive to make conflicted recommendations. And obviously there are significant new disclosure obligations. Implementation issues with respect to insurance companies. So one important thing to note here is that although insurance companies have an obligation to supervise sales transactions, they have no obligation to supervise in-force transactions. That's on insurance producers alone. The good news is that that's subject to a best interest light obligation, but it's still only on the insurance producer community. Second, insurers have the ability under the regulation to delegate their supervisory obligations. So as an insurance producer, you may receive some inquiries, some outreach from your carrier partners, hoping to amend your selling agreements in a way that reallocates the responsibilities relating to supervision. And third, producers are going to have to be trained on the policies and the best interest standard by insurers. Right now, there's already training on insurer policies. There's going to be the second layer of training that the insurance company is going to be coming up with respect to the best interest standard. Finally, just to close here, what are some practical steps for distribution firms as they seek to come into compliance with Insurance Reg 187? Well, one thing you can do is start assessing how best you can leverage your existing policies, processes, etc. So a lot of the broker-dealer firms already have intake forms, point-of-sale processes, hold recommendation processes, processes concerning consumers' financial ability that they're already obligated to have under FINRA rules, it makes sense to kind of take a hard look at those and see how they can be leveraged to meet your obligations under Reg 187. Second, you want to probably take a look at your selling agreements so you can anticipate the questions and the requests that your insurance carrier partners are going to ask for. Next, you should be reviewing the special provisions in Reg 187 relating to fee-based annuities, and reach out to your carrier partners to determine which of them offer both the fee-based and the commission-based version of the same product, and discuss with them the process for ensuring that your clients, your customers receive the necessary comparison forms that are required by the reg. And finally, you should kind of assess your training needs and work with your carrier partners to ensure that any training that comes down the pike meets any specific needs that you might have.
Thanks, Isa. Obviously an awful lot there. Excuse me. We're at the top of the hour. What I'd like to do, we received a lot of questions. Let us figure out the best way to get back on that. You know, a number of questions were, it's easy, so I'll take it. Can I get a copy of the deck? So you can. Just reach out to any one of us, and we'll give you a copy of the deck. The other, and I just want to take a minute on this, is aren't these state securities regulations, as they advance, aren't they preempted? And I just wanted to take a minute on sort of the framework for thinking about that issue, and then we'll talk more as we sort of figure out how best to respond to all the questions. But when you get that question about preemption, you have to look at it, right, from both the advisor side, from an SEC-registered advisor, and also the broker-dealer, because they're different frameworks. So I'm going to ask Michael to take the analysis from the advisor side for an SEC-registered advisor. Then we'll ask Holly to just give a little bit of the framework for the broker-dealer. We're just going to go another minute or two, and then we'll wrap up from there.
Sure. Thanks, Cliff. So on for example, Nevada, when you look at the statute and the authority pursuant to which it would be adopted, we did not think it would apply to SEC-registered advisors, given NISMIA, because there's not an anti-fraud provision. We understand, we have on very good authority that one of the trade groups has already reached out to Nevada on that issue, and Nevada said, correct, we did not mean to have our regs, our standards apply to SEC-registered advisors. So it looks like that will be clarified in the final version of the standards, that Nevada will make clear that it does not apply to SEC-registered advisors.
Great. So again, on the SEC-registered advisor side, you look at the states have authority, with respect to the anti-fraud, in terms of anti-fraud authority. But again, if it's not an exercise of anti-fraud authority, then the states really wouldn't impact SEC-registered advisor. Holly, could you just tee up the analysis on the BD end of things?
Sure. So on the BD side of things, Cliff, we look back at NISMIA, the National Securities Markets Improvement Act of 1996. That act amended Section 15 of the Securities Exchange Act, which, as you know, is the section that requires broker-dealers to register with the SEC. There's a specific provision in Section 15 that was added as a result of NISMIA that limits a state's ability, and the way that this provision is written, it includes reference to limiting a state's ability to adopt a law, a rule, a regulation, or any other order with respect to a broker-dealer that would have the result of making a broker-dealer make and keep records that are different from or in addition to SEC requirements with respect to books and records. So what that sets up is this interesting discussion about a state's ability, outside of its anti-fraud ability, to regulate broker-dealers. Can it adopt regulations that lead a broker-dealer to create new books and records that are not books and records that otherwise would have been created under SEC rules, which for broker-dealers we know, in the 34 Act, 17A3 and 17A4 are the principal avenues through which broker-dealers are required to make books and records. So that's sort of one of the issues, or one of the things that people are thinking about with respect to the Nevada proposed regulations are whether the regulations could in fact be requiring broker-dealers to make and keep records that they otherwise would not be required to make and keep.
Thanks, Holly. So that's why you'll see these regulations that come out from the state say, hey, broker-dealers, you're a fiduciary, but no new records, no new record keeping for that reason, in anticipation of the Ms. Mia argument. So with that, we're going to wrap up. And again, thanks very much for joining us. If you'd like to receive CLE credit, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. And once again, if you have any questions or if you'd like to receive a copy of the deck, please feel free to reach out to any one of us. And again, thanks everyone for joining. We appreciate it.
Thank you.
Thanks.
Thank you.